throughout the session. I think we are going to be okay on time, but we're going to be squeezed. So if you ask for your bill to go by, it's probably going to go to the back. And not making any promises that we're ever going to be able to get to it. We're going to do our best. Every bill gets at least one day, and the day you ask for it to go by counts as a day. So we will try to hear every bill substantively, but if we can't get to it, we can't get to it. We're going to try to start this committee on time whenever we can. There's a lot of busy folks who want to get in and out of here, so we're going to keep things moving. If your bill is not ready to be heard, we do not want to hear it. Keep that in mind. We'll find to work on bills that members of the subcommittee have issues, but we don't want to try to rewrite people's bills all day long. We have some new faces in here, so we have Delegate Hope joining us. Good to have you. Sitting here with Britt is Abby Broughton, she's a first-year law student at U of R, who's going to be popping in and out. We have old faces back as new faces working over here to my left. Thank you all for being back and for taking good care of us. Almost all the bills we have today are subcommittee members' bills, except maybe with one exception. We are going to present from the dais this year, or excuse me, from the podium this year. There's a lot of folks who have some very important issues, and we're going to treat them accordingly. We do have a couple of procedural issues. Delegate Lindsay has asked that we strike his HB 1510. Chairman Kilgore moves to strike. Delegate Leposse seconds. All those in favor say aye. Those opposed. All right, and then we have two bills that have been requested to take by for the day. Again, we are doing that at the patron's request. They will go to the back of the docket, and hopefully we'll get to them later. They are Delegate Lindsay's 1495 and Delegate Leposse's 1643. Move to second. Those go by for the day. All those in favor say aye. Those opposed. All right, I think we only have one bill, maybe from a non-committee member. That's Delegate Bell's bill. So if you come on up, we'll hear your bill. This is HB 1604, Foster Care Reasonable Efforts to Prevent Removal of Child. We have a sub that we had a printing problem, so the version of the sub we don't have in front of us, so it's coming. So why don't you tell us what your bill, sort of the goal, and then when the sub gets here, we can review it and adopt it.
Okay, thank you, Mr. Chairman. House Bill 1604 amends the Code of Virginia to be consistent with federal statutes which require that for children in foster care, when a child is placed out of state, at the time of the permanency hearing, a determination will be made by the court that the out-of-state placement continues to be appropriate and in the best interest of the child, and that each permanency hearing the court consults in an age-appropriate manner with the child regarding the proposed permanency or transition plan. And when a child has been in foster care for 15 of the last 22 months, the local board of social services shall file a petition to terminate the parental rights of the child's parents and concurrently identify, recruit, process, and approve a qualified family for adoption. There are exceptions to the requirement which include the local board finding a compelling reason to delay or not file the petition, or the child is being cared for by a relative. In addition, the bill adds federally required language addressing when reasonable efforts to reunify the child with their family are not required through multiple sections of the code. The language is currently in the code section on termination of parental rights and is being added to sections addressing removal from the home and entrance into foster care. The federal requirements have been incorporated into foster care guidance and foster care plan documents, but they remain unaddressed in the code. The requirements relative to court proceedings must be addressed in the code in order to satisfy the federal requirements, which allow Virginia to continue to draw down federal funds for foster care expenses. The lack of consistency between federal law and the Code of Virginia, as well as between the removal and termination sections of the code, could also lead to confusion and potentially a delay in achieving permanency through the adoption for children in foster care. The department has worked with the Virginia Supreme Court's Court Improvement Program in the development of this legislation. The local departments of social services are expected to support the bill because this requirement is already in guidance and impact would be minimal.
Can you explain, maybe we want to wait till we get substitute, is what the explanation you just gave, is all that apply to the substitute and the underlying bill, and the substitute just has some wordsmithing in? Is that what we have?
I think, Mr. Chairman, that's correct. Brittany can correct me if
426 through 428, 514 through 516. I believe that those are all the 30-day hearing requirements. Those are also removed from the substitute.
So before we hear from DSS, and for those members up here who do family law, note that what this is doing is setting a scenario where you don't have to use reasonable efforts to prevent removal of a child when there is a certain set of findings related to abuse and other things. Chairman Kilgore.
Yes, and my question relates to those certain set of findings, Mr. Chairman. And I was maybe Dickie or whoever knows the answer to this question. It is the parental residual rights of the child's parent over a sibling were involuntarily terminated. Is that current law, or is that something we're adding in?
I don't think we're adding anything in. I think, not in those terms anyway.
Okay.
That's current law.
Okay.
All right, why don't we hear from DSS on this, or whoever else is here testifying in favor of the bill? Come on up. So every year we have one of these bills from y'all, and every year there is a lot of pushback on what's specifically we're required to do by federal law, and what the implications of that are if we choose not to. So to the extent there's anything in there that isn't specifically required by federal law, let's also draw attention to that, and then some other folks have some questions.
Yes, sir. Good afternoon, Mr. Chairman and the members of the committee. Carl Ayers, Director of Division of Family Services. As Chairman has already mentioned, this is one of the bills you get from me every year that the feds change the law, and I've got to bring state code into compliance. Everything that is in this bill is specifically addressing federal requirements and allow me to pull down Title 40 funds. That's just strictly, the feds changed it and said you need to bring state code into compliance, so everything that is in this and that piece of it. There are some wordsmithing issues that have been brought up primarily between us and the Court Improvement Program, the Supreme Court of Virginia. That's led to it. The one amendment, the one change, whenever you will see the actual amendment come to you, is as it was originally drafted, it would actually require us to go forward with a permanency planning hearing before we could even get it in front of the court within that first 30 days. And so whenever we looked at that, the way it was drafted is we could not, as a state, even do the way the bill was drafted. So that was what brought the amendment, and then what Ms. Olwine worked on this weekend was just some further suggestions from the Court Improvement Program. And I believe the Court Improvement Program may have a couple of other suggestions that are not included in the amendment.
And just for me to be clear, all of these findings, that if they're found, then you don't have to take reasonable efforts, those findings could include behavior that occurred before the child issue was even born, right?
Absolutely. If you have, one of them is that termination of parental rights on another, involuntary termination of parental rights on another child. So if you have an involuntary termination of parental rights on another child, you can actually terminate parental rights on a subsequent child that is at the discretion of the court to do so.
Mr. Chairman.
Delegate Scott.
Yeah, just as a point of fact, the way it works now, you can petition for termination if a previous child had been terminated and it's prima facie evidence in the case. Now this language is not too much different than what's already in law, but there are provisions in here about the 15 and the most recent 22 months. I want to make sure, because that the language in here is what is required by the federal law, because when the bill first came out, it had this language that is now out of the substitute that had to do with permanency planning. And the way these foster care cases work, they go through a regular process, and the language that was in there would have totally disrupted that process. But now you've taken it out, so that's good. But I want to make sure that there's nothing else in here that's not language required by federal law that we really have to scrutinize to see how it works with the whole process. A very complicated process, and when you get to termination, you don't want to give attorneys the ability to pick it apart, but you want to be fair to the parents who are being terminated. The attorneys never pick anything apart, right?
No, sir. So, yes, Delegate Toscano and Mr. Chair, that is correct. My understanding, and as I tell you every year, I'm not an attorney, so the best my understanding from the guidance I've received is that the initial way the bill was drafted is what it says through the language is that you can actually perceive a termination of parental rights immediately in those cases. But those termination of parental rights, we haven't even had a chance to go in front of the court, have a dispositional hearing, and get everything needed to start the foster care case. And that's where the 30-day piece of the way Virginia system works, it would completely have thrown it on its head. So that's why it was taken out. The 15 to 22 months is a requirement that is currently addressed in guidance, but is not addressed in the code. And what the federal requirement specifically says is that if a child has been in foster care for 15 of the last 22 months, it doesn't have to be consecutively. They could have been in care, left, and had to disrupt it and came back in. That we are to proceed with finding another permanent plan on them, which includes the termination of parental rights. That is the specific code language that you're addressing. That is really kind of the emphasis for this piece of it.
Follow-up question.
Doug Scott.
Again, if you look at line 962 of the bill, it says under these certain circumstances, the local board shall file a petition.
That is correct.
And that is very different than what exists in present law. So is that a federal requirement or something that we just thought was a good idea?
No, sir, that is a federal requirement. If you have been in the custody of the department for 15 of the last 22 months, we shall file a petition to terminate parental rights to move to permanency. The federal government does not want children hanging out in the foster care system for any longer than need be, and that's why they included the shall.
Follow-up question.
Doug Scott.
I want to make sure that, again, these lawyers take a look at this, because the way termination statute is written, in fact, I didn't even know that 910.2 was a termination statute, so I thought it was 283. Oh, this is 63.2. You may have to do this in 16.1-283, which is a termination section too. But the way the termination section is written, you have to file a permanency plan documenting adoption as a new goal before you even file your termination petition. And I want to make sure that this language doesn't mess up that process. So, Brittany, maybe you take a look at that.
Mr. Chairman, Delia Toscano is correct that 16.1-283 is the ordinary termination of residual rights. The 63.2-910.2 is an added section. That's one of the big amendments to the bill.
Right, and it's being added in the section that, in the rest of the foster care stuff, right?
That is correct.
Yeah.
Mr. Chairman, I'm not sure it's in the rest of the foster care stuff, so we just need to make sure that 16.1-2. Don't you like this, Delegate Bell, having the lawyers pick this apart? 16. We just need to make sure that 16.1-283 is consistent with what we're doing here.
Well,
Because I get what you're trying to do.
and this is the question I had about comment that occurs before this child is even born. Under that section, that new language, 63.2, 910.2, it says they shall file for termination of parental rights if the person has done any of these things.
Right.
The person could have done that thing before the child was ever even born.
Right.
And so then we're directing you have to file to terminate their rights, even if they assaulted somebody, whoever this thing is, 40 years ago, has their whole life together, has a kid, then 40 years later, because now they have another kid, you're required to come in and terminate their parental rights, or file to terminate
We
their
are
parental rights.
required, as I mentioned at the beginning, this is all subject to the judge. We are required under federal code to file the petition. The judge certainly doesn't have to grant the petition. It's just one of those pieces that says, if you are convicted of this, we have to file that petition. And
Sure, so what that means is, anybody who is ever convicted of murder, voluntary manslaughter, felony attempt, conspiracy, or solicitation committed, if the victim of the offense is a child of the parent, a child who the parent resided at the time of the offense, or the other parent of the child, or felony assault resulting in serious bodily injury, all those types of things. Anybody who's ever done that, any subsequent kid they have, you have to file a petition to remove their parental rights.
that is how it is written. Yes, sir. You are correct.
And you're saying federal law requires us to adopt that?
Yes, sir. That is what I'm telling you. Okay. And that's why you need the amendment.
All right, so here's what we're gonna have to do. We're gonna have to take this, well, hold on, I'm gonna take it by temporarily before we get the substitute, but let's go ahead and, here, does anybody else have any questions for DSS while they're here? Did Doug Leftwich?
I may have been reading the bill when this was talked about, and if it was, I apologize for asking the question again. What happens if we don't adopt this? Lose funding, is that the?
That is correct. We are already under a Title IV program improvement plan with the federal government. And so this is part of our Title IV program improvement plan, is to bring the state code into line with the federal code. And so we are at risk of losing
Under the proposed revisions, it would be mandatory to file a petition to terminate, assuming that the parents met this criteria, correct?
That is correct, yes, sir.
You would agree with me that not all children that are in foster care are 4E eligible?
That is correct.
So this provision will nevertheless cover those individuals, even though that the state may not even be receiving federal funds for their care.
That is correct.
And this is the risk of talking about a bill before you have a substitute. So I asked you those questions about the termination of residual parental rights section at the end. It looks like there's now some exceptions to the shall, so that in the substitute, so it says they shall do it if these things happen, but then it says it's only at the option of the local board if the child is cared for by a relative, or they determine that the filing petition would not be the best interest of the child, or the local board is not provided to the family of the child in time established, blah, blah, blah. So it's a shall then with 3 exceptions, as I read it?
That is correct, and if I could draw your attention to exception number 2,
Right.
which I believe addresses most of what you're asking me about, if the local board has determined the filing of such a petition would not be in the best interest of the child, and has documented a compelling reason for such determination in the child's plan. What we don't want to do is for those situations, as you've asked me, if you had a child 40 years earlier and everything has been fine and it's been, if we don't want to move forward with termination, if we've got a reasonable best interest determination that it didn't occur, and that's why the exceptions exist.
All right, let's go ahead, unless anybody has an objection, let's go ahead and adopt the substitute, because it's not before everybody. A motion to adopt the substitute. Moved and seconded. Those in favor say aye. Those opposed, all right, the substitute's before us. All right, you have a question, PSS?
Yes, just a question, I mean, but realistically, under the, on page 36 at 956, and do the following, how often is the local board going to step in and say that we're not going to remove the child? I mean, I just think that's, I mean, some local person there at DSS are going to sit there and say, well, this is what we're going to do, and nobody on the local board's going to do it. I just don't see that happening, but.
In response to your question, Mr. Chairman, is that what we do is we promulgate guidance that explains to the local agencies for how this occurs. We already operate pretty much under this statute as it goes. It just has not been specifically in code. Our guidance to our local departments already has these pieces laid out into it. So this will change, and it's going back to Delegate Bell's talking points. Very little will change in current practice because we already operate this way.
This is already, Mr. Chairman. So this is already current.
This is current practice. It has just never been required by the federal law. So Virginia is way ahead from this end of it, and now we are bringing ourselves into compliance. The feds have changed it. We are already in compliance with this, so this will change practice 0 to little from what we already do.
All right, we've adopted the substitute. Anybody here else to speak in favor of the bill? Line up, introduce yourself and offer your testimony.
Sandy Carrison, Office of the Executive Secretary, Supreme Court of Virginia, and I don't speak in favor, but I do not also speak in opposition. I'm neutral. I have a concern to offer on behalf of the courts, and that is, if I could invite your attention in the substitute, which I have not studied, but to line 794. The new language requires, actually on 795, requires the court, it has shall language, to consult with the child in an age-appropriate manner regarding the proposed permanency plan for the child. And my point here has been, and I've shared it with Delegate Bell and also with the department, that the child may not be present, and yet this language directs the court to speak with them. The child it may not be appropriate, the child may be, as in a few emails that we've shared, may be medically fragile, there may be other circumstances that would suggest that it's not appropriate for the court to consult, so that my request is your consideration of a very, what I consider to be a technical change to say that the court shall, as appropriate, and if the child is present, consult with the child in an age-appropriate manner. Really appreciate your consideration of that concern. My other concern to raise is really for you. It's a policy matter. relating to the structure of the new definitions of being placed in 16.1-228, the general definitional section. That means, and I just offer for your consideration, that means that those definitions would now apply to criminal cases, and not just in child welfare cases. And so aggravated circumstances, for example. And I have with me a Court of Appeals opinion that happens to involve domestic violence, where the defendant argued something about aggravated circumstances because that language was placed in 16.1-283 and not in the general definitional section. The Court of Appeals rejected this defendant who had beat someone up so badly that they couldn't walk for 3 days, rejected that. The court said, no, that was aggravated circumstances, what you did, even though it didn't meet the other definition. So that's for your consideration. It's strictly policy. If you change it or you put it in that definition, the courts will apply it across the board in child welfare and in criminal cases for your consideration. My main point from the court administrative standpoint was the earlier point requesting that you consider softening that shall consult with the child if the child's not there or it's not appropriate. So thank you very much.
All right, thank you. Any questions? Before we hear from anybody else, let me hear from DSS. The meet with the kids stuff, that's federal requirement, I guess?
We're required to have a child to the court hearing if at all applicable. And so my discussions with the court improvement program are that specifically those circumstances that would be delineated for when the child is not present for the hearing, that would be better set for regulation and in guidance instead of listing them out specifically in the code. So that is where the difference between where I've been advised or where it would appropriately go versus how the court feels that it should go.
Okay, and what about this issue about where we put the definitions? What about this issue about where we put the definitions?
That is actually a question that I would direct Ms. Allwine as to where legislative services feels it's best appropriate.
Mr. Chairman, I think that we're trying to move away from having as used in this section throughout the code, if we can put it in the general definition section. I mean, it would apply to all of Chapter 11 of this title if we put them into the general definition section. So I think that that piece is...
Does that pick, are there other criminal provisions in Chapter 11 of whatever? I mean, aggravated circumstance obviously could be a relevant criminal finding in some other context. All right, while she's looking that up, get some better language for the guy to meet with the kids stuff, and have something like if available or if practical or if possible or something like that that complies with what the feds want us to do, but makes it clear that if the kid is, for health reasons or safety reasons or proximity reasons, physically unavailable, that there's some kind of built-in leeway for the court.
Well, the option that Ms. Harrison presented to you, but we're fine if you choose to go forward with that option from the department standpoint. If you want to use the language she specifically suggested, we are fine with that. We don't believe it changes.
All right, when you were saying it, I didn't love it, but I got the concept you're looking for, so let's look at this then as a subcommittee. The line is 794, in each permanency planning hearing and any hearing regarding the transition of the child from foster care to independent living, the court shall conduct with the child in an age-appropriate manner, if feasible or if available or if appropriate. I'm looking at members up here to see who might do this for a living, who might have thought on that. I'm just telling it to Scott.
Chairman, again, it raises this issue, what language do the feds require us to have versus what language do we want? Because when you say the court, that implies that that child has to come to the hearing. And oftentimes in these hearings, the guardian ad litem will recommend that the child don't come to the hearing because the child may be placed 3 hours away, may lose time from school. There's no reason, but the way this is written, it says the court shall, not the guardian ad litem shall, not the court shall hear from the guardian ad litem, none of that. So if it's not required in federal law, I think we need to make give enough flexibility that we can deal with what's best for the child in getting this done.
Well, specifically what I'll tell you is the federal government requires us in our 4E plan the children present in court. However, there are circumstances that child cannot be present in court. So specifically, if you have this here and we delineate what those options are in our regulation and our guidance, then we will be, in fact, meeting the requirement of the federal court. However, the federal requirement is that the child shall attend their court hearings. However, there are circumstances, and I wish it was delineated better at the federal level, but we have this discussion every year. It's not. What they tell us is they have to be a court. The fact is, you have children that are in the hospital, you have children that are incarcerated, you have all these different circumstances that the children cannot be present at the court system. So this was drafted to meet that requirement. However, we need to delineate there are situations where the children cannot be present.
What about if we said in each permanency planning hearing and any hearing regarding the transition of the child from foster care to independent living at which the child is present, the court shall consult with the child in an age-appropriate manner regarding the proposed permanency plan or transition plan of the child unless the court finds it would not be in the child's best interest to do so. You have a problem with that?
I do not have a problem with that.
All right. Court, you got a problem with that?
No, sir, I think that'll.
Anybody else have a problem with that? You did. All right, come on up, tell me the problem with that.
Chairman, members of the committee, and Valerie LaRue from the Virginia Poverty Law Center. We like this provision because we think it's really important that the court hear directly from the child. And I understand there may be situations where the child may be in a hospital and can't be transported to court. I certainly think if a child is incarcerated, they can be transported to court. People are transported to court from incarceration all the time. But the ability to hear from the child who, going into transitional living, is an older child, we're not talking about a 3-year-old or anything like that. I think it's really important that the court does hear from the child. I think that's an important provision. And to provide too many opportunities for the court just to say, oh, well, it wasn't possible, makes me concerned. There are ways in which the child could communicate to the court, perhaps by letter. I think the court does need to consult with the child. The court could also use many courts have the ability to communicate with people who are off-site remotely using video conferencing and phone conferencing. So I really like to see this kept in here. Thank you.
All right, so stay there, so make sure I explain this right, as I understand it, subcommittee, make sure we're all on the same page. So DSS says that we can do it as it is now, or maybe soften it a little bit. So which then makes it sort of a policy question for us. Do we want to mandate that at every one of these hearings, the child has to be there? And the way you do that is by forcing the court to consult with that child. So the court will either have to consult with the child or make arrangements to video conference or bring the child in or whatever. Or do we want the policy to be that they don't have to, but that, that's maybe the presumption, but there are some exceptions. So that would be, Chairman Kilgore.
I think there ought to be some exceptions. I just think it's sometimes impossible whether the child cannot communicate or doesn't have the ability to communicate, or as Delegate Toscano said, that the guardian ad litem said, there's no use for you to come today, that, you're 3 hours away or whatever. So, I mean, I think there does need to be something there.
Mr. Chairman,
Delegate Campbell.
and I know this from practice, there are circumstances where you have children whose goal will be independent living, who might be living in a secure residential facility, and they may have behavioral problems that poses a real security threat to that child, bringing them to court.
All right, so let's get the question before the committee this way. Delegate Luposi offers an amendment to this bill at line 794, 795, 796, Brett, you're listening, that says, in each permanency planning hearing and in any hearing regarding the transition of the child from foster care to independent living at which the child is present, the court shall consult with the child in an age-appropriate manner regarding the proposed permanency plan or transition plan for the child unless the court finds that such consultation is not in the best interest of the child, period. All right, that's the proposed amendment before the subcommittee.
Second.
So if you like the flexibility, you would vote for the amendment. If you don't want that, the Poverty Law Center indicated you want us to make sure that they have to be there every time, you would vote against the amendment. All right, so that amendment has been moved and seconded. Any debate on the amendment? And I'm going to give you a chance to speak directly to the amendment then. So if you have any additional comments.
Yes, Chairman, so in that amendment, you've basically provided 2 opt-outs. So one opt-out is saying if the child happens to be present, and then an opt-out whether it's the best interest of the child. So it seems to me that creates a situation where nobody's going to be motivated to bring that child to court, and that makes me concerned.
All right, anybody else here want to speak to the amendment? Come on up. Introduce yourself and offer your testimony.
Mr. Chairman, Richard Gary,
Association, but as a longstanding member of the Virginia Bar Association, currently a member of the Board of Governors, has long been the VBA's policy that the General Assembly should accord the judiciary as much discretion as possible on a case-by-case basis. I spent 20 years of my practice in this field dealing as a guardian ad litem for children. I can tell you that having a child, notwithstanding the feds telling us we have to have them there, one of the most traumatic things for a child is having to sit through hearing after hearing after hearing and relive the dissolution of their family. Not necessarily the abuse, but the dissolution of their family. And the best person to make a decision, after they hear the evidence, and they hear the argument of counsel as to whether or not a child should be present, whether or not a child should be consulted, and in what manner that child should be consulted, is the judge who has been living with this case since the beginning. And I would ask that the I would ask that the committee take that into consideration and give our judiciary the discretion they need to decide these cases. Thank you.
Chris.
Mr. Chairman, pardon me because I don't practice this area of law, but age-appropriate manner, isn't that already an exception? And what is the definition of that? Wouldn't that allow for a lot of this leeway?
Yeah, I mean, I read that to be you have to communicate, but you have to communicate to a 3-year-old different than a 12-year-old. But although my 12-year-old I communicate to like he's a 30-year-old.
Mr. Chairman, if I could, I can actually answer this question for you a couple of different ways. States have interpreted that statute in different ways. Some states have taken the very literal determination. They have taken children that are incomeless and have actually required them to go to the hospital where they're at, have a witness sit there and read the plan to them. Whenever they are in a coma, they have taken it that literal of a definition. Some other states have not. So whenever you get into putting it into practice, it goes differently depending on which state that you're in. From our piece of it, we were recommending the child should be there or shall be there for that end of it, and then we would spell out specific circumstances of where they would not be able to be present.
Mr. Chairman, if I may.
Doug Campbell.
Mr. Ayers, correct me if I'm wrong on this, but to be eligible for the goal of independent living, you have to be at least 16 years old. Is that not correct?
Well, actually, there is not the goal of independent living is not an acceptable goal, period, from that end of it. There are only three acceptable goals that the federal government gives us. I mean, independent living is strictly limited to those children that are 16 or age or older.
And how does age-appropriate manner fall into that? I can understand if you're dealing with a 3-year-old, but you're dealing with a 16-year-old here. I mean, what does age-appropriate manner mean, and how does that apply in that front?
In that circumstance, it's going to apply differently depending on the child that's in front of you. We have some that are severely limited, some that can understand a conversation like you and I are having. So in an age-appropriate manner, it is really ensuring that you are talking to the child, not using legal jargon that you as attorneys or judges to attorneys would understand, but actually making sure that you are talking to that child in a way that child can understand what you're communicating.
So it takes into consideration the various disabilities the child might have, and cognitive problems, things of that nature.
Correct, and that's what the expectation is, that the court would be able to consult in a way that the child can understand what is occurring in their court system.
I'm just not sure that the phrase age-appropriate manner would cover all that. I don't think the average person out there would understand that.
So again, I don't practice in this area. So it looks like this covers 2 types of hearings: permanency planning hearings and hearings regarding transition.
That is correct.
So could a permanency planning hearing apply? Is there an age limit when a permanency planning hearing occurs?
No, we're required to go to a permanency planning hearing. It's generally about 12 months from the day the child comes in.
Even if the child's 3?
Even if the child is 3. That's where we are moving to finding a permanent plan for the child if we can't get the child back home.
All right, so while the transition to independent living hearing might not happen until it gets 16 or over, the permanency planning hearing could happen for a child across the age spectrum.
It would be required to happen across the age spectrum, correct?
All right, so we have Delegate Posses's well thought out amendment before us. Anybody else want to speak to the amendment? Anybody on the committee have any thoughts on the amendment? Delegate Toscano?
Mr. Chairman, I like the idea of the amendment, but I think we might be better off just including your last clause, but not your first clause. So it's always the best interest standards that the judge can make that decision. And if the judge concludes it's not in the best interest of the child to either see the child or consult with the child, the judge can then say, no, I don't need to do that.
And so you're
If
saying
you're-
we have the second part, we don't need the first part?
If you have the second part, I don't think you need the first part.
Okay, I think that makes sense. Anybody have a problem with that? If Delegate Posse was to amend his amendment, make a substitute?
Is
Um,
posterity gonna know that
Yeah,
this is
no, it's, yeah,
permanently
because she's filming over there, so she's got us.
for permanency, that this is the posse amendment?
It's live streaming right now. To 8 people are watching it right now as you rewrite the foster care laws of Virginia.
I mean, we're just making rules.
Yes, ma'am.
Chairman, may I respond to that suggestion? And my thinking on that is that if it's not in the best, still, the court shall consult, directs the court to consult, and let's say that the agency didn't bring the child, but it would have been better if they had the child for whatever reason, and I don't have the fact pattern, but say they're 14, the parents, all the relationships are healed, and the child really should be there, but the agency, with all due respect, didn't see fit to go pick them up. So still the court shall, it may have been in the best interest of the child. My preference is if they're present, it puts a bit of an obligation on the agency to bring the child to court if it's appropriate, and I appreciate Mr. Garrett's comments that many times the guardian ad litem can represent, but the court can't consult if the child's not present, shouldn't consult if it's not in the best interest, so those are my comments.
All right, so keeping in mind, this is the first bill we've heard on the first day, and this bill's got a long ways to go still. We have the amendment as originally proposed with both the physical presence and the best interest is before us. That was the motion that was moved and seconded. Let's take a vote on that, understanding again that this bill can change a lot as it goes forward, and if somebody raises a legitimate concern about that, I expect it'll have more chances to be tweaked. So any more debate on the motion? This is the motion that originally made, has the physical presence and the best interest of the child exception. All right, hearing none, all those in favor of adopting the amendment say aye. Aye. Those opposed? All right, the amended substitute is now before us. Is there anybody else here to speak in favor of the amended substitute? Come on up. Introduce yourself and offer your testimony.
Mr. Chairman, members of the committee, James Pickrell with the Virginia League of Social Services Executives, we support the bill.
Thank you. All right, anybody else here to speak in favor of the bill? Anybody here speak in opposition to the bill? Harvey Law, do you have any general thoughts on the bill you want us to hear?
We'll move
I mean, it's cool either way.
Yeah, we're good. I'll move to report. She's
Mr. Chairman, I'd just like to say that we understand that this bill is mostly to bring the Virginia law into compliance with federal law. We like the idea of consulting with the children, and overall, we don't have any objections to the
Okay.
bill. Understanding.
Great. All right, anybody else here speaking in opposition to the bill? All right, hearing none, we have a motion and a second to report the substitute as amended. Any debate? Hearing Delegate Scott.
Mr. Chairman, I would just ask that Brittany take one more look to see if we have to drop some similar language into 16.1-283 and make sure it doesn't disrupt any of the presumptions that are in 283 in terms of termination. Because in the process of doing this, in the process of fixing something, we don't want to create an exception or change a burden that's in place right now.
Mr. Chairman, Delegate Toscano, so subsection E of 16.1-283 is the residual parental rights section. And it says that the residual parental rights of a parent or parents of a child who is in the custody of a local board or licensed child placing agency may be terminated. So that is a little different than what we have in the 63.2 edition. By the court if it finds, based upon clear and convincing evidence, that it is in the best interest of the child and that, 1, the residual parental rights of the parent regarding a sibling of the child have previously been involuntarily terminated. 2, the parent has been convicted of an offense under the laws of the Commonwealth or a substantially similar law of any other state, the United States, or any foreign jurisdiction that constitutes murder or voluntary manslaughter, or a felony attempt, conspiracy, or solicitation to commit any offense if the victim of the offense was a child of the parent, a child with whom the parent resided at the time such offense occurred, or the other parent of the child. 3,
Okay, well, let's do this. Yeah, let's vote on the bill, and then there's 2 things we want you to check. We want you to check to make sure that is consistent with this, and we want you not implying that Cotter has any kind of wisdom that isn't possessed by others, but want to run the potential criminal implications of these definitions. Okay. Yeah, let's do it again just so we can check the box. And so that's the other question that the court raised about the adding these definitions in this particular section. So we'll check both of those two things. And then will you make sure, because the bill's about to report, will you make sure if nobody votes against it that it goes on the contested docket? Randy, thank you. All right, that said, we have a motion to report the substitute as amended, moved and seconded. Here, no further debate. All those in favor say aye. Aye. Those opposed? All right, we'll put that bill reports unanimously, or recommends reporting unanimously, but we will put that on the contested docket. Nikki, I wouldn't come to hearing if I were you. I'd make these guys come to the full board's meeting. But do what you gotta do.
Thank you, Mr. Chairman.
Thank you, sir.
I thank the subcommittee for your willingness to help us get this right.
Appreciate it. Thanks for all you did. Thank you to all for being here. All right, so we have a bunch of bills from members of this subcommittee. Do we have Albo's bill today? Okay. So I think that's the only bill not from a member of this subcommittee.
Can I go to mine?
Yeah, you asked so nice. How about you go next? Delegate Posse. All right. So Delegate Posse actually has 3 bills. We're not prepared to apply the Searle rule to the Posse bills yet, where he gets to pick one. But we may. All right, first bill up from Delegate Posse. Again, his electronic wills bill, 1643, went by for the day. So 1646 is the form of garnishment summons. Maximum portion of disposable earnings subject to garnishment is our first bill.
Hello, my name is Brandy Singleton. I'm with the Court System Office of the Executive Secretary. This is actually a cleanup bill. In 2005, y'all changed 30-9, I believe it is, which is referenced on the garnishment form. Oops, sorry.
Forgot to change the form.
And forgot to change the section where the form is codified. We changed the form itself, so the form that people are using has been correct. But the code where the form lives has simply never been updated.
So just to be clear, since we did this, you've been using a form that's in violation of the Code of Virginia?
In order to accurately represent the law to users of the court system, we have.
Alright, so what you're asking us to do is to, after the fact, legalize the behavior of the court today.
That's what I'm requesting.
Thanks, alright. Alright, Bill Chairman, Delegate Campbell.
Does the clean hands doctrine not apply?
I think there's a few.
I watched it before I came.
Alright, anybody have a problem with bringing the Supreme Court into compliance with the law? Alright, we have a motion to report the bill moved and seconded. All those in favor say aye.
Aye.
Those opposed? Alright, the posse making laws. 1652, City of Richmond, General District Court, and that was a unanimous vote.
Thank you.
Motion report.
All right.
Alright, City of Richmond, General Court, current criminal jurisdiction. Is this the one that was requested by a judge in the General District Court because you've got the jacked up Manchester?
Yes.
Yeah. Okay. They've got 2 courts in Richmond with different jurisdictions?
All right, you want me to
Yeah.
you want me to bore you since the...
Yeah, do it quickly.
All right, I'll do it quickly. All right, so back like at the turn of the last century, not the turn of this, so between 1899 and 1900, okay? This is how far this dates back to. They had City of Richmond took on and took over Manchester. Manchester's right across the 14th Street Bridge. So basically, probably 3/4 of a mile from here is Manchester, which was a long way back in the day, but now it's a very short way. And it's all part of the City of Richmond. And so when they took over Old Manchester, they came up with this thing called the Manchester Compact, which was some agreement to always have a circuit court in the town, wherever that whole place is over there, Manchester. So about 12, 13 years ago, when I was still on Richmond City Council, Mayor Wilder decided to redo the Manchester Courthouse in such a way that we would have the General District Courts meeting over there. But because in the City of Richmond we have separate courts, we have Richmond City Civil, we have Richmond City Traffic, and we have Richmond City Criminal Division. We have all three divisions. So we had, when we hired a judge, we would hire him to do solely civil stuff. To my knowledge, we're the only jurisdiction in the state of Virginia that has operated this way for these many years. So they're trying to get us into the 21st century, and so they're going to, this started back probably with Senator McDougal taking away, all these head clerks, because we had like 4 or 5 head clerks making head clerk money.
And just to make sure, you already have concurrent jurisdiction in civil matters and in traffic matters, and you just want concurrent jurisdiction in criminal matters too.
That's right, and what this allows is for them to adequately sparse the resources with the police and all the rest of it amongst the various spots in the north side and south side, so they can spread the wealth amongst the judges, so to speak.
And does this only apply to general district court?
Yes.
Okay, so we're not messing with jury pools or anything else like that?
Circuit court's always been, for the last probably 10 years, in John Marshall Court's building 2 blocks away.
And just so everybody understands, the folks who are operating the Manchester courthouse think this would be a good idea, as I understand it?
Yes.
And the city of Richmond have an opinion on it?
Everybody's happy. It's just the administration of justice in the city is going to be done more efficiently, correctly.
All right. Any questions for the patron? Anybody here speak in favor of the bill? Anybody here speak in opposition to the bill? All right, we have a motion to report. We have a second. Moved and seconded that we report HB 1652. Any debate? Hearing none, all those in favor say aye. Aye. Those opposed? All right, 1654. 1654, let's go ahead and hear 1654. And then do we have Chairman Alvo back there? Fossey? All right, you're up after this one.
Can you come forward? Explain what this really is.
Mr. Chairman, members of the committee, this is a bill dealing with the fees of commissioners of account. The fees of commissioners of account are set by the circuit court in which the commissioner of accounts operates, with the exception of a few fees which are set in statute. In 1996, the Judicial Council got concerned that the circuit courts were not in conformity with how they were setting the fees, and they set a uniform fee schedule that was recommended to the circuit courts. That got fairly wide adoption, but it began to fall out of sync with the costs and expenses, and the court finally updated that fee schedule in 2008, and that has been adopted pretty much by all of the circuits as we go through. In 2016, they had another update of their uniform fee schedule, which has now been adopted in most of the circuits. The regular review of the fees and the conformity of the fees around the state are important, both for the uniformity and for the health of the commissioner system. There are a few fees that are set in statute. This is one of them. The statement in lieu fee has been set in statute in the same amount since 1993 and has not been changed. What this would do, what this bill does, is it removes the statutory setting of the fee and brings it back within the control of the circuit courts and the Judicial Council, so that this fee can be adjusted from time to time as necessary for the health of the commissioners.
And so the Judicial Council would then still set it on a statewide basis, it just wouldn't have the $75 cap on it?
That's correct.
Okay. And just for the subcommittee's knowledge, I think this bill there's a version on the Senate side, I think some tweaks have been made too, so if we send this bill forward as it is, we're going to have a few more opportunities both in a House bill and a Senate bill to work on it and end up bringing something in uniformity at the end. Okay. Doug Mitchell.
Thank you, Chairman. Just thinking out loud, if we take off the $75 cap, what's the potential upper threshold that states could pay? I mean, is it a reasonable standard, or based upon the number of man and woman hours that the commissioner of account will make? I mean, if you're trying to forecast the state expenses, trying to figure out how much you're going to be cutting the check to the commissioner of revenue, commissioner of accounts on, any idea where you can figure out what's going to be ahead?
Yes, sir. Mr. Chairman, Dr. mentioned the fee would be a set fee. It would be set by either the circuit court or in the fee schedule by the Judicial Council. It's not something that's going to be a floating fee. so that the Judicial Council would have the opportunity to recommend $100, $125, $150, whatever, and then the circuit courts would adopt that as their uniform fee going forward.
Thank you, Mr. Chairman.
Thank you.
All right. Any further questions? Anybody here speak in favor of the bill? Anybody here speak in opposition to the bill? All right, last word, doesn't want it. We have a motion on the bill. All right, we have a motion report, moved and seconded. Any debate? Hearing none, all those in favor say aye. Those opposed?
Thank you, Mr. Chairman.
All right, Chairman Alba. 1654 report, recommend reporting.
Thank you, Mr. Chairman.
I think my bill number is it 1456?
1456, Albo custody visitation orders, parenting time. We had a version of this bill last year. I think there was some hope folks could work some stuff out, and you're back before us.
Okay, so to jog your memory, a lot of divorce and family law attorneys have found in their private practice that if they use the word parenting time, the non-custodial parent doesn't feel like a second-class parent, and it really calms everything down and makes everybody happy. And when everybody's happy, then you have less litigation, and you can actually get a settlement agreement with custody. So I passed this. I tried to pass a law last year, but the bar actually was pretty smart, and they said, you know, you can't just do a blanket statement by taking the word visitation, inserting parenting time in the code, because you might have grandparents or you might have abuse and neglect. So they promised, and they lived up to their promise to study this and come back with a suggestion. So what they've come back with is what you have before you, which is a bill that says, in the case of any proceeding involving custody or visitation of a child, as to a parent, the use of the phrase parenting time is synonymous with the term visitation. They also came up with an idea that they would do it upon request of a parent, and I thought originally that was going to be a good idea. I had an attorney call me and say, what if you have a bad acting parent who demands to use the word parenting time when that parent might be an abuser or that parent might be otherwise bad actor, and that would force the judge to then have to use the term parenting time. I'm wondering, and I'd like to have your all's opinion on it, what if we just made the whole bill just say, in any case or proceeding involving custody or visitation of a child as to a parent, the use of the phrase parenting time is synonymous with the term visitation, and then let a judge just decide when it's appropriate or not, and just leave it at that.
Yeah, so if you're looking at the bill, Chairman Alba's looking at like line 61 through 69. That first sentence is what he just laid out, then the second part of that is parent asked, and then the exception for the bad parent stuff. So ultimately, we'll have to decide whether or not we like the bill at all, just the first sentence, or the whole thing. So, okay? All right, Cheshire, do y'all, family law, y'all want to speak to the bill? And specifically speak to this issue that Chairman Alba has raised about if we just did the synonymous and then left it with a period and struck the rest of it after that.
Thank you, Mr. Chairman. I'm glad to hear that we're smart enough to suggest that we make some changes and that we came through with what we had promised. The concern that I would have about changing it is that we wanted to kind of take it away from there being fights over whether it's called visitation or called parenting time. That the purpose in putting that it was upon the request of a parent and that the court shall use it was to take away that argument, to take away there being hours of discussions in a courtroom about whether it should be called parenting time or visitation. If you go farther down,
We really have a judge who would let you debate that for hours in your courtroom?
it's possible. I doubt it, but it's possible. Or the parties are going to be talking about it, or the parties are going to use that as a way not to settle a case. Because there may be one party who doesn't want to call it parenting time and the other party wants to call it parenting time. I would liken it to when you talk about a reservation of spouse support. That argument goes away when you say that if I walk into court, I get it as long as there's no adultery. So there's no argument about a reservation of spouse support in general when you're settling these cases because you know it's a given. Under our scenario, it would be a given.
So you like the bill as introduced and you would not like us to drop that stuff off?
I do, because if you look at the bottom, it talks about if there's a history of family abuse. So if the case that there's a history of family abuse, Mr. Garriott's talking in my ear, then it wouldn't apply, the court wouldn't have to apply it. So I think it gives an out to what Delegate Albo has talked about. But,
You like the bills introduced?
I do. Can I have Mr. Garriott talk about it?
Sure.
Mr. Chairman, this is not my area of expertise, and these are the experts. And maybe if they believe that my concern is not going to happen in the real world, I would defer to them.
So I like the Albo concept more than the bills introduced, but it's not my bill. So, all right, anybody else here speak in favor of the bill? All right, anybody here speak in opposition to the bill? Or just to the bill and you're kind of ambivalent? Come on up.
Chairman, I'll speak to the bill. I actually like it much better as amended. I had a few concerns the way it was drafted originally, partly, and I've already spoken with Delegate Albo by email about this, about making it mandatory rather than discretionary for the judge. The judge is the one who's hearing all the facts, who knows if there's been allegations of abuse. The other thing for parents who are, whose children may be in custody of DSS, who are diligently working in good faith to get their children back, I think parenting time as applied to them, which the original proposal would not do, is actually a good thing because it would give them a lot of motivation to keep working to get their children back. And again, the judge is in the best position to decide, is this parent working in good faith? Is this parent actually working diligently to regain custody of their child, or are they just going through the motions? And so I think a judge would be, again, the best place to make that decision and make that call. So as amended, I think it's actually a nice thing for parents to have parenting time.
Come on up.
Thank you, Mr. Chairman, members of the committee. Echoing a few of the comments by the Virginia Poverty Law Center, just would prefer that the court have the discretion to use the term parenting time or visitation in an order. And with all due respect to the family law's position, if one party can mandate, that a particular word is used in an order and is more heavy-handed, that also gives parties something to fight about afterward. It may get an order entered, but it could be a motion, for a show cause summons because the parent is using the word visitation instead of parenting time. So
if we struck everything after the first sentence and instead of saying they may use it, just said they were synonymous, is that accomplishing what you're talking about? Do you like that?
I would not have stood up to give my neutral comments had you made that change.
I love how she's neutral.
Thank you.
Thanks,
Mr. Chairman?
Delegate Toscano.
So if you left the first sentence in and just started it, the next sentence, upon the request of a parent who is a party to such a case or proceeding, the court may, in its discretion, may use the phrase parenting time instead of visitation.
I don't even think she needs that. She just doesn't strike it after visitation.
Mr. Chairman,
Yes, ma'am.
the other concern that we had, and this was part of Delegate Albo's global bill, was that we didn't want to have circumstances where you had an abuse and neglect case and you had somebody calling it supervised parenting time, and they felt like that they were going to be allowed time outside a DHS office, for example, because their parenting time was parenting time and not visitation. So that was one of our concerns, and that's why we wanted to kind of carve out the abuse and neglect cases so that we didn't have that problem.
Okay. You can totally see how legislation turns into this. So you start with a really easy idea. Parenting time is the same as visitation. And then someone goes, well, we should only do that if someone asks for it. So we add that sense in. And then they go, yeah, what if a bad guy asks for it? We don't want him to be able to ask for it. So then we put the exception to that in. And then we end up with this paragraph.
If it means that it's discretionary, I don't have a problem with that. But I'm concerned about taking it only for the first line. If you want to put in there that the court may instead of shall.
So if we said, in any case or proceeding involving the custody or visitation of a child as to a parent, the court may use the term parenting time to be synonymous with the term visitation. Everybody be cool with that, right?
Yes,
Okay.
that would do what I wanted it to do originally.
Delegate Lapazzi offers that as an amendment.
We still keep it in the,
And then strike all that other stuff.
but what about the concern about
Yeah, the
the
other stuff you need for the abuse and neglect.
67 down?
But it's court's discretion.
No judge is gonna call parenting
Yeah.
time when you beat your kid up or have sex with them, they're not gonna call it parenting time.
That's true.
Supervised visitation.
Right. And if a court, I mean, at some point, let's let them be judges. And if they want to use the term, explain what it means.
And again, you know, we love judicial discretion, but the thought was if we made it mandatory, that it would take away a fight.
All right, so Delegate Lapazzi does not want to make that amendment, so I'm soliciting somebody else to make the amendment that would say, in any case or proceeding involving the custody or visitation of a child, the court may, in its discretion, use the term, quote, parenting time to be synonymous with the term, quote, visitation, period, close quote. All right, we have that amendment moved and seconded.
For posterity, that's the Toscano.
Right, the Toscano amendment. So that would strike line 61 through 69, and that would be the new language.
Yeah, it was straight 97.
Yeah, in any case or proceeding involving the custody or visitation of a child, comma, as to a parent, comma, the court may, comma, in its discretion, comma, use the phrase, quote, parenting time, close quote, to be synonymous with the term, quote, visitation, close quote, period. Good with that, right?
Yeah.
All right, moved, seconded, everybody's happy, right? That's what I'm talking about. All right. Any questions from anybody on the panel? All right, those in favor of adopting the amendment say aye. Those opposed? All right, the amended bill is now before us. We have a motion report, the bill is amended. Moved and seconded, any debate? Hearing none, those in favor say aye. Aye. Those opposed? I bet we're right back to exactly what your bill last year said. We're not, okay. And just to be clear on that amendment, there's actually two sections in the code where the language comes up, and Britt is capturing that amendment. It was in both sections, so it's line 97 and line 61. And if that needs to be a substitute, you'll make it a substitute. All right, thank you, sir.
Remember how nice we were? I'll remember. Thank you.
All right, Collins, you have a bill? Yeah, we have Collins as a bill. Come on up. House Bill 1692.
Good afternoon, everybody. 1692 basically codifies Crawford, which is the 1994 ruling, that circuit court and juvenile court both have concurrent jurisdiction. However, this simplifies it a little bit more so that when a divorce proceeding is concluded, when a circuit court has referred the matter, has concluded the matter, and they say we'll refer things to juvenile court, the parties can still file in the circuit court, so we avoid double filing fees, double attorney fees, as we file in one court and get moved around. So this eliminates some of the duplicity, which is in our juvenile court system.
Okay? All right, anybody here to speak in favor of the bill? Come on up.
Mr. Chairman, the Virginia Family Law Coalition does support this. As I understand it, in certain jurisdictions, the divorce was concluded. There would be a motion to reopen a case filed, and then the court would immediately refer the matter down to the juvenile court. There may be some discussion about whether this is a good use of judicial resources because the matter might be best heard in juvenile court. But what you're going to have is you're going to have a referral to juvenile court. You're going to have a trial that may be 3 or 6 months down the road on a show cause for failure to pay support. Then you're going to have an appeal, and it's going to be back in circuit court anyway. So we believe that this is a codification of what the law is, and that there should be concurrent jurisdiction and the ability for a party to refile in the circuit court and have it be heard in the circuit court.
Okay. All right, anybody else here to speak in favor of the bill? Anybody here to speak in opposition to the bill? Does the court have an opinion on anybody from the court?
I got a motion
All right,
to report.
motion to report. It's been moved and seconded. Any further debate? Hearing none, those in favor say aye.
Aye.
Those opposed? All right, move to report. Thank you, sir. I guess all you have. Doug, Lindsay, did you want to, were you going to strike the one that we took by for the day?
That's 1495.
All right, so we've already moved to take that bill by for the day, so someone who voted on the prevailing side needs to vote, and voted on the prevailing side, we reconsider the motion which we took 1495 by for the day.
So moved.
Moved and seconded. All right, all those in favor of taking 1495 by for the day, say aye.
Aye.
No, you want to do the opposite of that? All those in favor say no?
No.
Okay. Or maybe not. So we've now got the bill back before us. It is not taken by for the day.
I've had the pleasure of speaking with, Mr. Chairman, I've had the pleasure of speaking with the stakeholders, and I understand the reasoning behind their concern, and so I move to strike my bill.
Okay, so then we have a motion to strike House Bill 1495. Moved and seconded. Any debate? Hearing none. All those in favor say aye. Aye. All those opposed? All right, so we struck your 1510 and your 1495.
Yeah, well, you didn't need to tell people that.
I'm just making it clear. All right, thanks, man. Okay, all right, that was the last bill of a non-committee member, so we can just go down in order unless someone needs to be somewhere else and needs to go right away. He left because he got on appropriations. He left us last year. Now he's not coming back. All right, we'll just go in order then. BRS, you're up if you want to take the podium. Then Leftwich, you'll be next. This is self-settled spendthrift trusts allowing other legal entities other than trust businesses to qualify as a trustee. House Bill 1448.
Thank you, Your Honor. I have Jeff from the Virginia Bar Association is going to provide a little bit of insight. I just want to let the committee know that this comes with the recommendation of the Virginia Bar Association Trust and State section. My understanding is the legislation simply corrects a reference to those who can qualify as a trustee, and the Virginia Bankers Association has reviewed this legislation and has no objections. Jeff.
Come on up, introduce yourself and offer your testimony.
Jeff Palmore, Lane Smith on behalf of the Virginia Bar Association. So this deals with self-settled spendthrift trusts. A spendthrift trust is one which neither the beneficiary of the trust nor its creditors can reach the assets contrary to the trust terms, and it's self-settled when the settlor is also a beneficiary of the trust. This legislation really just fixes a technical issue as to who can serve as a qualified trustee. When the statute was recodified in 2012, a reference to Title 6.2 was included that refers just to banks and trust companies, but there are other entities such as law firms or charitable organizations that can also serve as qualified trustees, and so this would make that change. With the subcommittee's indulgence, as we were sitting here, we think that there's an errant comma on line 14 that should also be addressed at this opportunity. At the end of line 14, so the definition of independent qualified trustee is supposed to mean someone who is not any of the things listed on lines 16 through 28, or someone whose actions are directed by those folks. But the extra comma changes that meaning. So at the end of the line, the comma after the word not.
Yeah, the comma on line 14 says who is not, comma, and whose actions are not. It should be and whose actions are not subject to direction by.
Just to read that.
All right, so do we have a motion on that amendment to strike the comma at the end of line 14? All right, moved and seconded. Any debate? Hearing none, those in favor say aye. Those opposed, Rick, do you have that? You like that comma? All right, Kilgore votes no. Right, regarding that comma.
Contrary to the Posse amendment.
We're going to let Napasi explain that amendment on the floor. All right, so with that, you support the bill. All right, does anybody here else support the bill? Anybody speak in opposition to the bill? All right, seeing none, you generally support the bill, just not the removal of the comma. Okay, all right, final word, he declines to take it. Anybody in the committee have any further comments? All right, hearing none, we have a motion to report as amended. Moved and seconded that we report House Bill 1448 as amended. All those in favor say aye. Aye. Those opposed? All right, that reports unanimously again. All right, Leftwich, House Bill 1479.
Is there a way to go to my next bill, Your Honor?
You have another one? Oh, I'm sorry, Leftwich. 1523.
I have a member of the bench here to testify.
Sorry, this is appointment of sub-judges district court. Sorry about that.
Judge Long, I'm going to open up his brief remarks, and then I have a distinguished member of the bench from Virginia Beach General District Court, Judge Long, who's here to testify. I've had multiple conversations with some of you on the committee, and it's interesting. Everybody seems to have their own unique horror stories in their private practice of experiences we've had with substitute judges. I've had just in the last several months a substitute now the circuit court judge of the locality essentially comes up with a list of substitute judges for everybody. That includes JDR, that comes with GBC. Obviously, our circuit court judges are all of them are retired judges by nature. What this does essentially says the judges that see the attorneys that are in the courtroom every day are the ones that are the ones that understand quickly, the ones that are the best to be able to serve in that capacity. Obviously, particularly when we think of JDR, that is such a unique creature. You have a lot of attorneys that go in the circuit court that never walk in the doors of JDR and vice versa. So I want to turn it over and let Judge One provide some testimony for the committee so you can have a better idea of why we're
Great. Thanks. Come on, give yourself an offer testimony.
Good afternoon, members of the committee and Chairman Habib. My name is Daniel Lana. I'm in the Virginia Beach General District Court. I approached Delegate Miaris about this issue back in the fall. For as long as anyone is aware, the list of lawyer substitute judges that are available for us to use when we do not have either another sitting full-time judge or a retired judge subject to recall available. Those list of lawyer substitutes have been appointed by the chief judge of the circuit court. I frankly don't know how that came to be or when, but it has been for all of my private practice career and my judicial career. The concerns that some of us have had is twofold. One is that the lawyers that most regularly appear in front of us, we have the ability, I believe, to know who might make good substitute lawyer judges, both by temperament as well as knowledge of the law. The second concern is that oftentimes lawyer substitutes get appointed by the circuit court judges, but then whenever we call upon them, they are busy and we can never get them. Thirdly, these are folks, particularly in a large jurisdiction like Virginia Beach, who we have to work with. And in a large jurisdiction like Virginia Beach, with the caseload that we have, one of the things that we have going for us currently in our court is the ability to shift dockets around to make sure that cases are handled as quickly as possible. And some of the lawyer substitutes seem to understand that, and some of the lawyer substitutes seem to have no clue about that. And so it's a source of frustration amongst at least the members in my courthouse, and I know from talking to a few other judges at judicial conferences year to year, similar concerns have been raised. So that's the genesis.
Let me ask you a question about the mechanics of sub-judges. So the circuit court judges pick the list of people who are qualified as sub-judges. They go through whatever training with the court they go through, and then the chief judge of the general district court actually selects the sub-judge to hear any particular case or particular docket, right?
That is correct, with one caveat. And here, speaking of the garnishment summons situation, there's a difference between what the statute says and a difference between what actually occurs. What the statute says is in cases of illness, vacation, other absence, or conflict that requires recusal, the chief judge of the general district court would pick. First, we are required to see if there is a full-time judge willing to sit. Second, we're required to see if there is a retired judge subject to recall available to sit. Only if neither of those two are available do we look to the list of lawyer substitute judges, and the chief general district court judge by statute would then pick. That's what the statute says, and that's what does occur in situations of illness or vacation. In situations of recusal, however, what we are directed by the Supreme Court to do is to notify them that there is a conflict and that we need a judge to come in and hear that particular case, either because that for whatever reasons the recusal occurs and there is no other judge on the bench willing to hear the case. And so in that situation, the OES then designates a judge, usually a retired judge, to come in and hear that case.
And that may happen if, for example, you had a practicing member of the bar before you get a criminal charge and the whole bench recuses itself and the Supreme Court would appoint somebody.
That would be correct.
Delegate Lupasi.
Your Honor, I understand the issue as you all have articulated it. times when I have been in front of sitting general district judges that they didn't understand about moving the dockets along.
True.
And I've been at times in front of general district judges that I thought didn't know the law, although I'm sure they thought they knew the law, and they probably were right, but in my mind they weren't. I think a couple things. It seems to me that this issue does have a way, in some ways, of working itself out. The persons that are put on your list by the circuit court, if they stink, y'all don't typically call them back. In other words, they're just sort of written off. And then the other thing is, I'm sure that to the extent that you all communicate with the circuit bench, you let them know that this person underperformed and why. So that, and the other thing is, been my experience around here at least, that to the extent that someone is highly capable, then I would think that that one of the circuit court judges would ask you all, hey, what do you think about this person, or what do you think about that person, so that you all are involved in it in some way. So I'm sure that happens.
If I could speak to the last part first. In theory, it would be great if the circuit court judges consulted the general district court judges. In practice, I will tell you that it was this year for the first time that I am aware that that occurred, at least in Virginia Beach. There's no requirement that that occur, and I don't think in many jurisdictions it does occur. I'm certainly not going to suggest that in no jurisdictions does it occur. Speaking to the first part, to the extent that there are lawyer substitute judges that we deem not suitable for whatever reason, you're right, we don't have to call them. The problem then becomes we have a declining list of availability.
Right, they use your spots.
And it would seem to me that our goal should be to have the best possible list, and we're not infallible. I'm sure that if we are granted the ability to do this, we will occasionally pick someone we wish we hadn't picked.
Totally possible.
I'm not, and Your Honor, I understand basically the issue. I will just say that my guess is the simple fact that you all are standing here and that Delegate Miyares has thought that this is of such an important concern that he would propose legislation as it relates to it, and I can see the value in what you're proposing. That to the extent that there's Virginia Lawyers Weekly here that's going to write an article that every judge in the Commonwealth is going to read, every circuit court judge in the Commonwealth is going to read, my guess is you're going to get a lot more communications from the circuit court, would be my guess. And so I don't know whether or not the legislation will pass, but I think that the point will have been very well made, and I think it will help correct some of these anomalies.
Well, Supreme Court, could y'all add to your training materials with your circuit court judges to encourage them to consult with the lower court judges when picking their sub-judge list?
We certainly could, and this is certainly an institutional conversation that has happened and happens, and that doesn't necessarily rectify the dynamic in every jurisdiction. We actually have no institutional position on this bill. I did want to bring something to y'all's attention, which is another statute that governs sub-judges, and it's the one that the judge was referring to that lays out the order of preference. First you go to a fellow judge who's sitting, then you go to a retired judge, then you go to substitute judges. But it says, and this may be a logistical reason, that the appointment is vested with the circuit court, because it says that in designating a substitute judge to serve, the chief district judge shall, whenever possible, select someone who does not regularly practice law in the court requiring the substitute, which means that, particularly the longer a district court judge is on the bench, the lawyers with whom they are familiar are folks who practice in the very court, And so this is not a bar, if you're inclined to vote for this bill. And the reason for that is that there's a Senate bill that has been introduced to strike the provision that I just read to you from the code. So I just wanted you to be aware of that.
Yeah, well, and the problem he's pointing out is that you're getting people who don't know the court. That other section's actually saying pick people who don't know the court. But wait, well, my question is for you. If we're not inclined to report this bill, could you give us assurances that you're going to work with your training materials to instruct circuit courts to be more thoughtful of the opinions of their lower courts in making these selections?
I hesitate only because, yes, certainly, this is a conversation that will undoubtedly occur, and more than once. That I can say.
All right. Is there anybody else here speak in favor of the bill? Anybody here speak in opposition to the bill? Did you get to say everything the court wanted to say? Okay. All right. Any questions for the patron? Delegate Hood.
I do have a question because I understand the problem that you're trying to solve, and I think the way you're going about it might upset the equilibrium that we've had for decades here. My question is the communication work is a two-way street. And have you thought about, Your Honor, talking to the circuit court and sending a list of names of people you come across in your daily practice who might be people that would be a good substitute, and send them a list of names? And you could draft legislation that says something like, after consultation, substitute judges shall be appointed by the chief judge. I mean, I understand the problem, I do. And I don't think your bill's gonna pass. I'm not gonna vote for it as is, but I do believe that maybe you could write something in the code to suggest that this is a conversation that they could solicit names from you. They don't have to choose them, but they could solicit them.
I was thinking the same thing. Is it a practice right now where you're not proactive and you don't provide a list to the circuit court judge, to the chief justice?
In the most recent iteration, and I think that the most recent iteration may have been the first one since I came on the bench, but I've been familiar in my prior 30 years of practice of how things went. In the most recent iteration of the list, there were communications back and forth. And so certainly we can, as a court, indicate to the chief judge, we understand that the list is up or there's some vacancies on the list and here are some suggestions. Certainly there are situations from perhaps courts to courts where that's not welcome. I'll just leave it at that.
I could just, could I provide a just?
Yep,
sorry. I think at the end of the day, this is a bill that essentially says the judges that are in that courtroom that see the attorneys that darken their halls every day have the best assessment of who's best to step in and substitute. And I know there were some sentiments of allowing the quote work itself out, but when you're a private citizen and you're having to spend thousands of dollars dealing with litigation and you have to get in front of a substitute judge, oftentimes it takes several cases or several times before it reaches a critical mass before that substitute judge is pretty much noted not to serve. And he is not there present when there's a substitute judge. In the instances I have, not in Virginia Beach, but in another jurisdiction, but you have to factor in that the other judges will become aware of when a substitute judge is just getting it wrong. And so I just goes back to the heart of I think the judges in the courtroom are the best ones to assess who are the attorneys that are competent, either at the GDC or JDR. I just ask for the committee to report it.
So I say all the time, don't let's say by anecdote. This kind of strikes me as a let's say by anecdote based on particular experience in particular circuits. I can tell you, in all the circuits where I practice, the sub-judges are probably held in at least as high regard, if not more, than some of the regular judges sitting in that court. And I think whoever you have picking, you're going to end up with some people who get picked who are the wrong choice for various reasons. We pick every now and again the wrong person to sit as a full judge. I know, every now and again, mainly in Arlington and Alexandria, Fairfax. So, I mean, it's my inclination that I think this is I think this is an anecdote in search of a solution in particular localities that ought to be fixed in ways other than legislating a total change where we fix up judges. This is my opinion. All right, the bill's before the committee. Any further debate? All right, we have a motion on the bill. Want to move to report it? Move it to the table? Okay, we have a motion to report.
Substitute motion.
All right, substitute motion.
Move to lay the bill on the table.
All right, we have a motion laid on the table. Do we have a second?
Second.
All right, that motion has been moved and seconded. That's not a favor motion. All those in favor of laying House Bill 1523 on the table say aye. Those opposed? All right, thank you.
Thank you all.
All right, Delegate Leftwich. You have, I believe, 1479 and 1608. We'll start with 1479. This is the Attorney Discipline Procedures Bill. I State Bar's probably here for this one.
Mr. Chair, members of the subcommittee, House Bill 1479 would reduce duplication in bar complaints. Prior to the bar kind of creating their own process for disciplined attorneys, a statute was enacted which allowed a complaint against an attorney to be filed in the circuit court. Since that time, the bar has created a process which has been very well vetted and works very well to discipline attorneys. And so what the former the statute we're trying to amend does is it will allow a complaint to be filed with the bar and then have a parallel action filed in the circuit court, which would bring what should be confidential proceedings out into the daylight. And we've decided as a policy matter that if an attorney is called out in public, it's going to be a bar process if they've done something that is merits that. So really what this bill does is just eliminates the circuit court proceeding unless the person who's subject to complaint elects to have it go through the circuit court. So that's it in a nutshell.
Anybody speak in favor of the bill?
Good afternoon, Mr. Chairman, delegates, members of the committee. Michael Robinson, I'm the president of the Virginia State Bar. I'm here and more than willing to answer any questions that the committee members may have. Otherwise, I think the delegate has laid out the bill and the reasons why it should be reported.
And just so for clarification, just so I understand, this would leave in place the current bar investigation process. At which point does the bar process become public if there's a founded issue? So I know there may be some people who think that we're taking a currently transparent process and making it not transparent. At what point does it become a public issue?
Right, and this would not change that aspect of the disciplinary procedures that have been laid out by the Supreme Court. That becomes public when the bar has determined that there is a reason or reasonable cause to bring charges against a lawyer. So once the bar investigation determines that charges should be brought, that is made public.
So the only thing that's confidential is the bar's initial investigation to determine if they should go forward. The moment they decide to go forward, it becomes public and it's a public proceeding.
That's correct.
And do you have any numbers as to the number of bar disciplinary proceedings that happen through the bar versus the circuit court process? My understanding is the latter is a fairly unique occurrence.
It's a fairly unusual or unique occurrence. I don't have numbers. I think an institutional memory says that over 20 years there may have been a handful. We have had occasions where a complaint has been made with the circuit court, and then when it was referred over to the bar, it had in fact already been reviewed.
Okay. All right. Anybody else? Any questions for Chairman Barr? Yeah, Delegate Mitchell.
Thank you, Mr. Chairman. First of all, I want to commend the State Bar. I had some questions of this bill. You came to my office last week. We appreciate that at the time. But let me ask a question. Under existing law, as I read it, if a court observes that an attorney has been convicted of a misdemeanor involving moral turpitude or a felony, that court can sua sponte make a referral to the State Bar. And of course, as I see an attorney performing on the docket, and it's public knowledge that person was convicted of a felony or misdemeanor moral turpitude, the judge can make that referral. As I read Doug Leftwich's bill, that court power to make the referral sua sponte is being taken away. Would I be reading that correctly?
I believe you would be reading that incorrectly, and here's why. Judges always have the ability to report suspected or observed misconduct to the bar. And in fact, the judicial canons lay out circumstances in which a judge should report an attorney's conduct.
Yeah, so you are reading correctly that we're striking that language, but I think what they're saying is they still have the ability and the obligation as members of the bar, members of the bench, to report such conduct. Under their rules that govern it, we're taking out the statute, but they still have that obligation.
That's correct. It simply would be pursued as a bar investigation.
Thank you.
All right, any further questions? All right, anybody else here to speak in favor of the bill? Anybody here to speak in opposition to the bill? All right, hearing none, you get the last word. You're all good?
Move the report.
All right, we have a motion to report. All right, moved and seconded to the report, House Bill 1479. All those in favor say aye.
Aye.
Those opposed? All right, 1479, recommend reporting. All right, House Bill 1608, this is a revisit of the UFADA PAC stuff.
Mr. Chair, I also have 1516.
Gotcha, I missed that one. 1516, surviving spouse elective share.
Okay, this is really kind of a technical amendment, and it is to simply indicate that when the spouse takes the elective share, that they're also, that would be in addition to taking a homestead exemption, which was an oversight in the bill that I submitted last year and was brought to my attention by a professor at William and Mary, for anybody who's William and Mary. And we've got Mr. Palmore here who can answer questions.
Mr. Chairman?
Doug Mitchell.
I couldn't hear it too clearly, but I think Delegate Lefferts was name dropping a certain school. I didn't hear that too well. Could you repeat that?
William and Mary, which did not accept me, so I say that with great respect.
This is a law professor, Bill?
Yeah, kind of, sort of.
All right, come on. You good?
Nothing to add, Mr. Chairman. Jeff Palmer with the Virginia Bar Association. The VBA supports the bill.
And emergency clause, that's just because you think you get the votes, or?
No, sir. The bill from last year on the augmented estate goes into effect, went into effect on January 1. That's just to make sure that the two align as closely as possible.
Okay. All right, anybody here speak in opposition to the bill? All right, hearing none. You have a motion on the bill? You move to report. Motion to recommend reporting. When LaPosse's helping with you with your motions, that's kind of a low point.
I'm gonna have to write it down.
House Bill, all right, we have a motion and second to recommend reporting House Bill 1516. All those in favor say aye. Aye. Those opposed? All right, that's unanimous, Andy. All right, now we're up to 1608, the UFADA bill.
Okay, Mr. Chairman, members of the committee, if y'all recall, a couple of years ago, I carried the UFADA bill, which was subsequently enacted in a different form called the Privacy Expectation and Life Choices Act. Since that bill was adopted, which was sponsored by Senator Obenshain in the Senate, the Uniform Law Commission had reconvened, included to a greater extent members of the technology industry, and they came to peace in the valley on a singular bill that could be pushed and supported throughout the entire United States. So I would strongly recommend that this bill reported, because it would make Virginia's policies uniform for throughout the U.S. And I would say it's a jobs bill, because it lets the tech industry hire people and have uniform laws throughout the country.
This is a repeal and replace very bad legislation. Okay. Anybody here speak in favor of the bill? And before we heard from the Law Council, we also heard from all the technology industry professionals and all those folks, and everybody is together on this bill this time, right?
Everybody's on board.
Okay. It is a fairly significant piece of legislation lengthwise, and it's all new words, it's all italics. So, I know everyone's had plenty of time to read it, so we're all good that way. Well, is this?
They went to the Joint Law Commission, JCOTS, I'm sorry, and they looked at it. Their negative feedback.
Are we striking all that we did before and passing this. So the second enactment clause, which is Article 3, that's the repeal part, right? And then the replace part would be all the new italics language? Okay. All right. Any questions for the patron? All right. Delegate Minshew.
At the risk of mixing up the acronyms, a couple years ago, Doug Leftwich, you had UFADA and Senator Obenchain had PIAC.
This is RUFADA.
What happens to PIAC if your bill gets adopted? Is this gone?
Yes.
It's verboten?
That's the second enactment clause on 363, 364. That's repealing the PIAC.
Oh, that is PIAC. Thank you,
You're
Mr.
putting in the UFADA. Okay?
Thank you.
We have a motion on the bill?
So moved.
We have a motion to report, moved and seconded, that we recommend reporting, we're on House Bill 1608. Any further debate? Hearing none, those in favor say aye. Aye. Those opposed? All right, good job. All right, Delegate Hope, we're up with your 1492, then Campbell, I think we have one or two bills from you. We need this, actually, at the request of the patron, strike House Bill 1584, Delegate Campbell's bill. That's moved and second. All those in favor say aye. Aye. Those opposed. And then Doug Campbell, are we hearing your 1586 day, or did you want to take that one by?
If we can take that one back from the day, we've been working on line amendments, and the original bill's gotten truncated to the point I think we're gonna need a substitute.
Okay, so we have a motion to take by House Bill 1586 for the day. Move second, all those in favor say aye. Those opposed. All right, that leaves us with Delegate Hope's 1492, and then I have two bills, 1617, 1618, we'll go after. So, all right, Delegate Hope.
Thank you, Mr. Chairman, members of the subcommittee. This was brought to me by some special needs trust attorneys and family law attorneys from my county. What it would do is give the courts express authority to order that child support payments be paid into special needs trusts or the new ABLE accounts for disabled upon the request of the parents. This will protect the payments from being considered as assets that frequently will offset SSI payments for the disabled child. Frequently what happens is that if the payments are too high, you get no benefits, SSI payments, and you could lose Medicaid eligibility. And in some cases, because the services are more expensive, some parents will just forego the child support payments just to remain Medicaid eligible. So this would protect that. The judges don't realize that they have this authority to direct that payments be sent into the special needs trust, and this would give them the express authority that they can do that. And that's what the bill does.
Making sure that we're keeping a quorum here. I think we're right on a quorum now, so if anybody else needs to leave, let me know. All right, anybody here speak in favor of the bill?
Thank you, Mr. Chairman, members of the committee. Richard Garrett, Virginia Family Law Coalition. We have vetted this and we support the bill.
And have y'all looked just to make sure we don't have any Medicare problems? You know, they're all, the Secondary Payer Act, all that kind of stuff.
This actually solves that, because it now will not interfere with the ability for the child to receive services and income, whereas before, if the child support was being paid, it would have to be reported, and potentially it could affect not only their disability, but more importantly, their services. And so this is really necessary so that the court can understand that they can do the special needs trust in terms of the distribution, and then it will not interfere with those issues.
Okay. I see that question. I thought it was a smart question, and it just betrayed ignorance. Delegate Toscano.
I like this idea. I'm just curious. The bill uses the term special needs trust, and it sounds like it's very broad. I mean, is there any risk that something could come into play here that we don't want? I mean, special needs trust is for someone usually under a disability.
Right, there would have to be a special needs trust established by the parent who's receiving the support. We didn't want to get too much into that. They would have to do that through private counsel. The people that do that know what to do.
That's how you do it.
That's how you do it.
You nailed the report.
I coached them up.
We have a motion to report. It's moved and seconded. Any debate? All right, hearing none, all in favor say aye. Those opposed? opposed? All right, that, we recommend reporting there. The last two bills are my bills. I'm turning the gavel over to Chairman Kilgore.
All right, back to my old chairmanship here. All right. Which one do you want to do first? 16, 17, legal malpractice. Whoa. Whoa.
So, Mr. Chair, members of the committee, 1617 is in response to a case that got a lot of attention. We are about to lose our form, I think.
Is there a substitute?
No, I'm just making sure that we.
We're okay, we have
Oh, we're okay,
six.
tap out. Okay, sorry about that. So the case was where some lawyers wrote a will, and many, many, many years after writing the will, a third-party beneficiary who was supposed to take under the will didn't because of an error in the drafting of the will. And so that third-party beneficiary, both not as a party to the contract and long after the drafting of the will, filed a legal malpractice action. And the court found that you had standing due to your third-party beneficiary nature, and that the statute of limitations didn't begin to run until the death of the testator. And so the result of that is, when you draft a will, you literally have, in statute of limitations, it is as long as the person may live, and the universe of potential claimants against you includes third-party beneficiaries, not just those people you had a relationship with. So this fixes both of those things.
So right now, if I had some wills out here,
yes,
the statute of limitation doesn't run until.
Correct. So if 20 years ago, somebody came to you and said, I want you to write in my will and leave my money to the SPCA, and you wrote to the SPTA instead of the SPCA, and then they died 40 years later, not only would the statute of limitations not have run, but the SPCA would have standing to bring that cause of action. So what this does is says that the claim is limited to the person that you have the relationship with, unless in the contract with your client it indicates that that person has standing, the third-party beneficiary. And it says the cause of action begins to accrue when the relationship ends. So when you screw the will up, that's when the cause of action runs, not 30, 40, 50, 60 years later when the person dies.
Who contacted you?
Yeah, so the State Bar has been working on this issue, trying to resolve it, and is in favor of the bill.
All right. So anybody who wishes to speak in favor of the bill, please come forward.
Mr. Chairman, the Virginia Bar Association supports this bill.
Thank you. Anyone wish to speak against the bill? All right. Do I have a motion on the bill? Move to report, Mr. Chairman. Have a motion and a second to report. All those in favor say aye. Aye. Opposed? Okay, that bill passes. Next.
All right, 1618, and there is a substitute for this one that we need to adopt.
Do I have a motion we adopt the substitute? I have a motion to adopt the substitute. All those in favor say aye. Aye. Opposed? All right.
So this is a hyper-technical non-exoneration issue. The question is, there's a scenario that potentially could occur where debts on property that have to be satisfied at the passage of the owner could lead to liability for the executor of the estate. I can't fathom how that can happen, but they say it could under a very, very rare set of facts, and so I believe if I'm enunciating right, this bill is meant to make it clear that that's not the case, and there's a notice provision in there. Anyways.
So what are we trying to fix?
Trying to fix a scenario where an executor of the estate could theoretically be held liable for the debts of the estate for an asset that passes at the time of death. And so there's a lien on a piece of property or whatever, and you're supposed to sell the property to satisfy the judgment, and then it could come back on the executor.
Okay.
I know that was.
Does that sound close enough?
Pretty close, yes, sir.
Pretty close.
Mr. Chairman, I don't want to overstay my welcome, but basically we have an issue with the non-exoneration statute passed in 2007. The debt that is on the property that passes to the specific devotee is the debt of the decedent. And to the extent there is a problem later with that debt, they can come back against the heirs to collect the debt. More importantly, they can come back against the executor personally to the extent he has dispersed the estate. What we've got is a situation where executors have gotten frozen if they have knowledge of the situation, and if they don't have knowledge, they've got a time bomb that can come back to bite them. This is an attempt to resolve that. It basically allows the executor to put the creditor on notice that there is a problem with the ability to exonerate that debt, creditor then can file a claim. The executor can then request that the devisee remove the debt from the property. If he can't do so, the executor would then have power of sale. If he does sell, it would pay the debt and the balance would go to the devisee. That's basically how this works.
Mr. Chairman, question?
Yes.
So wouldn't the executor now require the beneficiary to sign a release in case something like this happens before they distribute the funds?
You were talking about a refunding bond. That's a practice that's in the code, but is very, very rarely used. And basically, most of the executors now simply disperse it, get a receipt from the beneficiaries and go. To go to a refunding bond, what we found is they don't generally get honored. And the person with the deep pocket who was the first person to be hit is the executor, and he's the one who actually gets no benefit from the legacy.
Delegate Winchie. Thank you, Mr. Chairman. Thank you, Mr. Rush, for giving that hypothetical you gave about 50 seconds ago. But the shut off question in my mind walked me through. What if the debt on the property is underwater, and the debt is more than the fair market value or what a judicial sale would yield? Play through your scenario in a scenario where the debt is more than the value that the property brings at the sale, and how that would work out in the estate situation.
What you would have is the same situation I went through. You'd go through the notice, you'd go through the claim, you'd go through the sale of the property would not be enough to satisfy the debt. The remaining debt would still be a debt of the estate, but the executor would not have made disbursement at that point. He would have money in the estate to pay that.
Thank you, Chairman.
Maybe.
But if there's not enough money in the estate to pay the debt, including that property, the executor has no liability. He's only liable for the assets of the estate.
Right.
That's the problem.
Chairman? Yes. So what if the executors made an initial disbursement and it was too high? I mean, is there any way to?
If you can call up your beneficiaries and say, please give it back. It's a difficulty. I'm a commissioner of accounts in Fairfax, and we advise all of our executors to try to budget and try to be aware that there are claims that can come and not to be doing disbursements that are going to put them in a posture where they don't have the money to pay the debts they know of. In this circumstance, you know of the debt, but you have no ability to pay it because it's on property that's being separately devised. This is a way of getting them the ability to pay it.
All right. Anybody else wish to be heard for or against? Yes.
Mr. Chairman, Mel Tall with the Virginia Bankers Association. We appreciate the Commissioners of Accounts and Mr. Rust giving us the opportunity to work with them on the bill and listen to our concerns and address them in the bill. And we're comfortable with the language. We support the bill.
All right. The Bar Association supports the bill as well. Okay, thank you. Anyone else?
Chair, I have a motion.
Yes.
Motion to report the bill and with
A substitute.
report the substitute as presented.
Second.
I have a motion and a second to report the substitute. All those in favor say aye.
Aye.
Opposed? All right, that carries.
All right, that's our last bill. We meet Wednesday, full Friday.
Where do we meet?
Wednesday, we'll be back across the Capitol unless Andy can find a way to sneak us in here.
Okay, I'll do my best.
But it'll be the Capitol.
Mr. Chairman, I'm not sure about Friday yet. I don't think Delegate Alves is this.
All right, you can adjourn us. That's what I'll do. Are you going to adjourn? Kilgore, adjourn. Adjourn.